parent standing to file a lawsuit in Texas against a parent or to obtain possession and access to a child, one must first start with a definition of a parent. A parent is defined by the Texas Family Code as the mother, a man presumed to be the father, a man legally determined to be the father, a man who has been adjudicated to be the father by a court of competent jurisdiction, a man who has acknowledged his paternity under applicable law, or an adopted mother or father. The litigants who do not fit within the statutory definition are generally grandparents, collateral relatives, and someone who may have actual possession and control of a child where you have a missing parent. The Troxel case out of the Supreme Court of the United States sets the benchmark or the floor of access to children by non-parents. The language of the case has heavily influenced all litigation regarding the rights of parents, grandparents, same-sex parents, step-parents, and other extended family members regarding conservatorship and access to children. In the Troxel case, an examination was made to the 14th Amendment to the United States Constitution, which provides that no state shall deprive any person of life, liberty, or property without due process of law. It also provides a heightened protection against governmental interference with certain fundamental liberty interests. The court reasoned that there is a presumption that a fit parent acts in the best interest of the child, and so long as the parent adequately cares for the child, there is no reason for the state to interject itself into family matters and question the decisions of a fit parent. The types of standing under the Texas Family Code to file a suit, there are 3 sections which we will discuss in this video. The first section is the general standing to file suit under section 102003 of the Texas Family Code, in which there are 14 categories of individuals or entities that can file a suit. An original suit may be filed at any time by a parent of the child through a representative authorized by the court, a custodian or person having the right of visitation with or access to the child appointed by an order of a court or another state or country, a guardian of the person or of the estate of the child, a governmental entity, an authorized agency, a licensed child placing agency, a man alleging himself to be the father of the child, filing in accordance with Chapter 160, subject to the limitations of the chapter, but not otherwise. Chapter 160 has to do with presumed fathers, DNA tests, acknowledgments of paternities, which are the subject of another video. The person other than a foster parent who has had actual care, control, and possession of the child for at least 6 months, ending not more than 90 days preceding the filing of the petition. A person designated as the managing conservator in a revoked or unrevoked affidavit of relinquishment under Chapter 161, or to whom consent to adoption has been given in writing under Chapter 162. A person with whom the child and the child's guardian, managing conservator, or parent have resided for at least the last 6 months, ending not more than 90 days preceding the date the filing of the petition. If the child's guardian, managing conservator, or parent is deceased at the time of the filing of the petition. A person who is the foster parent of a child placed by the Department of Family and Protective Services in the person's home for at least 12 months, ending not more than 90 days preceding the date of the filing of the petition. A person who is a relative of the child within the 3rd degree of coincidentity as determined by Chapter 573 of the Texas Government Code, if the child's parents are deceased at the time of the filing of the petition, or a person who has been named as a prospective adoptive parent of a child by a pregnant woman or the parent of the child in a verified written statement to confer standing executed under section 102.0035, regardless of whether the child has been born. In the subsections as read to you, there is subparts 9, 11, and 12, which the court sets out various time requirements for someone to have continuous and uninterrupted access to the child. And then the court should also consider where the child's principal residence during the relevant time period prior to filing the commencement of the suit. Sections 102.003A9 and sections 102.004 are probably the most common avenues for standing of a non-parent. Each of these provisions, along with applicable case law, is something that you'll need to consult with an attorney prior to filing your suit. Section 102.003A8, a man who's alleging himself to be the father of a child can maintain his standing even if he's excluded as the father by DNA testing. The man alleging himself to be the father of the child can still challenge DNA test results. These are the most common provisions to seek access to a child by a non-parent. Then at the same time, you have a section 102.003A9, which was created to allow standing for those individuals who have developed and maintained a relationship with a child over time. This section also imposes legal consequences for parents that delegate their rights to third persons. It also should be noted that section 102.003A9 does not require a person seeking standing to show that the appointment of a parent as a managing conservator would significantly impair the child's physical health or emotional development. This is a common standard when you are asking without having actual possession access of the child, and therefore a parent has not delegated to you, a non-parent, their role as a parent, that if you want to seek access to a child because you have developed a relationship with the child, but that is through the relationship both with the parent or through perhaps day visits, that if the child's not actually lived with you, you have to show a significant impairment should the parent decide that you will have no more possession and access or time with that child. Another avenue for which you may sue for standing to get access to a child is under section 102.004, standing for a grandparent or other person. In addition to the general standing to file suit as provided by section 102.003, a grandparent or other relative that is related by the third degree may file an original suit requesting managing conservatorship if there is satisfactory proof to the court that the order requested is necessary because the child's present circumstances would significantly impair the child's physical health or emotional development, or both parents, the surviving parent or the managing conservator or the custodian, either filed the petition or consented to the suit. The grandparent access or access by a relative is pretty common in Texas under this section to attempt to obtain rights and duties to children. So the right for which a non-parent is attempting to get many times is going to be the right to determine the domicile. To be able to get possession and access to a child for visitation is generally a higher burden when you have developed that relationship with a child through time, and then you are to have family feud with the parents, but you still want to see the child. Resorting to litigation generally is difficult to get some type of court order to establish. The term I would use would be possession and access versus the right to determine the residency of the child. So if a parent has delegated to you the duties that normally they would have, and you've had possession access to a child for an extended period of time, which is generally up to 6 months, then to file suit to have the right to determine the residence, to make educational decisions and medical decisions for a child usually becomes extremely easy. However, if you have family members for which you have perhaps your own children, and those children were to play with their cousins, and then you generally watch those children, and then that relationship is terminated because of family feud, and you desire to file suit to have some type of court-ordered possession access as a non-parent, then the burden becomes extremely difficult to establish some type of court order to allow that visitation to be ongoing. My name is Michael Busby. I am a Houston divorce and family law attorney. If you like my video, please subscribe. Thank you.